very specialized field. Not everybody can do it. And you need to have very specialized skills to be able to do it. So we would manage the trust in compliance with South African laws. As Greta said, that is our fiduciary duty, which we take very seriously. We preserve the future of the beneficiary through our independent wealth management. And then obviously we care for the beneficiary. And that is something that is very dear to our hearts. I'm sure maybe through personal experiences or family or friends, that you know someone that is seriously injured, and it is not a simple matter. And so we make sure that we've got the specialized medical people involved as well that can assist when needs be. Greta, you'll sign to me if I'm talking too fast. Okay, so quickly, let's go back to the beginning, personal injury law. So if you go into an attorney's website, you'll see all sorts of different descriptions for what law firms do. And sometimes it might be a little bit confusing. So I thought, let me go back to the basics. So personal injury law actually covers two fields of law, primarily in South Africa. The first one is medical negligence law, and the second one is road accident fund claims. So those of you, I'm not sure, who have been following the news will see that the road accident fund, or the RAF, as we commonly call the road accident fund, there's been a lot going on there politically and all sorts of things in the news. But the RAF was actually set up by the government many years ago to assist innocent victims who were injured in motor vehicle accidents. That is the purpose of the RAF fund. They are funded by a levy on petrol and diesel sales. So whenever you go and fill your car up at the petrol station, there's a levy that you will be paying that goes towards the road accident fund. So if an innocent victim suffers, the passenger or a driver or a pedestrian, they will then be able to claim from the road accident fund, which should be a simple process. But as we know, over the last couple of years, it has become very, very tricky. And those of you who have experienced it will know that. Then you get the medical negligence law, which is a specialized area of law that a lot of attorneys, it's actually become more and more specialized over the years because let me say that differently. Many attorneys used to do medical negligence law as well as other law. But what we're seeing lately is that many attorneys are now either focusing on medical negligence law in its entirety, or they don't practice general law and medical negligence law because it is complex. And once again, there are very, very many challenges in this area of law. You may be suing if you're a medical negligence attorney and you're acting on behalf of the plaintiff. You may be suing the MEC of Health, which would be the MEC of Health would be if there is an injury or there's a problem with a birth, for example, in a government hospital, or with staff or with doctors. The medical negligence attorney would then sue the MEC of Health on your behalf. And if it's a doctor in private practice or at a private hospital, they would then be engaging with the insurance company who represents that doctor or that hospital. So that's just something to be aware of. Please ask questions if there's anything in more detail, but I'm going to cover it quickly so we kind of don't stick on it for too long. We know, well, I think you may know that the courts are very, very backed up at the moment. Some attorneys were getting cases set down for 2029, 2030. And so you can imagine the utter kind of tragedy of that when you've got very, very injured plaintiffs sitting there, needing care, needing help, and the courts are so backed up. So what happened in May is that the judge president in Gauteng issued a directive that every single civil matter in Gauteng needs to go to mediation first. The idea behind this was that it would speed matters up, and that instead of the courts having to deal with every matter, that you would be able to have a skilled mediator who would be appointed, and they would then hopefully be able to manage and arrange a settlement or find a settlement between the parties. So that is currently a few attorney firms, one attorney firm and one attorney association have taken this to the Constitutional Court. They don't agree that it's the right thing. So we'll see what happens. But as I said before, most cases take years to be finalized, and either they'll be finalized out of court through negotiations, or they'll proceed to trial where a judge will determine the liability and the compensation. More often than not, and Greta worked at the Road Accident Fund, and so she can attest to this, in years gone by, the Road Accident Funds didn't go to court. But now, as a matter of course, they do. And the Road Accident Fund matters are actually largely responsible for actually the court processes being clogged up at the moment. So that is one of the major issues that the attorneys are facing. So if you are dealing with an attorney at the moment, be patient with them, because I promise you they are doing their best. Okay, so if an attorney finds that they have an injured person who, for whatever reason, is unable to manage their own affairs, they will need to make application to the High Court. So this would not be a magistrate's court matter. This would be a High Court matter where an attorney would need a right of appearance in the High Court, or they would need an advocate to go to court, and they would need to apply for a curator ad litem, who would be able to act in the best interests of the patient during the legal proceedings, because they're not able to act on their own behalf. And so you would need someone to represent their best interests in the proceedings. But this doesn't happen just arbitrarily. There needs to be supporting medical evidence from various medical professionals to support this opinion. It would be at least one medical professional would need to support that, but usually there might even be 2 or 3 that would be in agreement saying that this person does need assistance from a curator ad litem. The curator ad litem is usually a senior legal practitioner or advocate. Different provinces work differently. For example, in KZN, there's a list of advocates and legal practitioners who are available, and often the judges will choose from one of those. Different provinces, for example, in Cape Town, they might have 2 or 3 that are submitted, and then the judge will choose from one of them. So it does work differently in different jurisdictions. Okay. The curator ad litem will do his investigation, his or her investigation, and they will compile a report which will go to court. And the court will then consider the mental capacity of the patient as supported by medico-legal reports, the suitability of the family to protect and manage an injured person's funds in terms of the purpose of the award, and also the suitability of the trust management entity that's recommended by the curator. So they want to know that these people, this trust management entity, will have, that they're competent, that they're transparent, that they have good standing, and who are they? You know, who are they represented by? Sometimes they want to even know who the trustees are in their personal capacities. So the courts take it very, very seriously. And just for your information here, to say we are only going to be referring to a situation where a curator ad litem recommends a trust. We're not going to go into where a curator ad litem would recommend a curator bonus. I will a little later on go into the differences and the benefits of each. I'll do that quickly. But for purposes of this presentation, I'm only going to deal with the trust, with what happens if a trust is recommended. Okay, so if satisfied, the court will then issue an order appointing a trust company, and the court order that the court then makes.
Is okay. What's your name again, Uncle?
Oh, sorry, there's someone that's not muted. Can you hear me? Is it fine? Okay. The court order will set out very important instructions relating to the case and to the trust. And that court order is absolutely gold. It is what we use later on when we set up kind of the parameters of the trust. We refer back to it all the time. And because obviously that is what the court has decided, once it's heard all the parties in the particular case, and the court has decided what is best in the best interest of the beneficiary. And that is our fiduciary duty as a trust company to make sure that the beneficiary or the injured person, we can use various terms, beneficiary, injured person, claimant, client, all the same person, that they are well taken care of and that the money is used, the financial award is used in their best interests. The attorney will then introduce the trust company to the family, and together they will explain the road forward. So as we know from dealing with these attorneys, often they've got very close relationships. They've worked with these injured parties for many years, but they will now hand the client over to the trust company, who will then take matters from then on. So the attorneys often then will also want to make sure that they're handing over to someone that is credible, because this is someone that is obviously has become very dear to them over time, and they need to make sure that they're going to be well cared for. The trust company, usually, it's not always, but often in the court order, they'll say within 6 months, must register, and that's if at all possible, must register the trust with the Master of the High Court. And the injured person is the sole beneficiary of that trust. We at Rodel, we usually use the name of the beneficiary, and the trust name is the name of the beneficiary, and that always reminds us who we are acting on behalf of. Sometimes there are delays at the master as well, unfortunately, so we do our very, very best to make sure that we can expedite that as quickly as possible. In different areas, different masters act with different expediencies. So yeah, but we do push and we do our best to get that trust registered as quickly as possible, because once it's registered, only then can we start to actually manage and help the trust, the beneficiary as we'd like to. What's very important also is once the trust is registered, and Greta will discuss this in more detail, the trust management company also needs to manage the expectations of the family, as well as the implementation of the medical and other needs of the beneficiary. And often in that first meeting, Greta and the ladies in our trust administration office will determine what is the first and most important need of the beneficiary. And we try and get onto that as soon as we can, because obviously sometimes it's really urgent because it's been many years. So that is something that we'll need to do. So just quickly, and as I said, I can come back to this if there are any questions, but the curator bonus versus disability trust has kind of been an ongoing kind of complex issue with our courts. Some of our courts, for example, in the Western Cape, the judges far prefer curator bonus. We don't quite know why. And so when the attorney feels that a trust is in the best interest of the claimant, they kind of need to argue quite vociferously for that. But then in other areas of the country, the judges and the courts prefer a trust. So we kind of take each one as it comes. And obviously we look at, and the attorneys look at which we believe would be the best for the beneficiary. So these are some kind of obvious differences between the two. So when a trust is appointed, you don't have any succession issues. And by that, what we mean is if a curator bonus should pass away, that would obviously naturally cause a huge delay with the management of the claimant's issues, because they now need to reappoint a new curator bonus, and that can be very, very can take a lot of time. Whereas if there's a death of a trustee, that is not an issue, because the actual trust company gets appointed as they get appointed, and they are represented by natural persons. So the death of a trustee is not a cause for a delay in the injured person getting their care. Then in terms of disbursements, a curator bonus needs the permission of the Master of the High Court for some of the expenses, and this can also cause delays. Whereas the trustees, they act according to the trust resolutions and the court order. And this can often expedite matters, especially, for example, when there's a vehicle that's needed for transport purposes, or there's a wheelchair that needs to be fitted into a vehicle. So to make a big purchase like that would need permission, express permission of the master, whereas the trustees can act according to that. If it's in the trust resolution and it's in the trust or in the court order, there's absolutely no issue with us doing that immediately. Okay, also in terms of administration, and once again, we would look at the injured person, how complex are their needs? A curator bonus is one person responsible for everything. So if it's a simple injury, it's not a major injury, often a curator bonus is the correct way to go. But if you've got someone who suffered a severe injury, they need medical attention, and sometimes the award is quite large, that needs to be managed, and it needs a team of experts to manage it. And for example, at Rodel Fiduciary, we have 3 qualified fiduciary experts, Greta, would we call them? It's actually a diploma that you can do, and it's quite a difficult diploma, but we have fiduciary experts, we have attorneys, we have accountants, and we have financial planners and medical case managers that we outsource and they are on our panel, and we vet them very, very, very clearly, because they obviously are very important in terms of our functioning and in terms of getting the claimant their care. So that is the difference in terms of administration, a team versus one person. So the financial statements, transparency, as we know, is a huge, huge issue when it comes to these claims. There has been a lot of fraud with, unfortunately, attorneys taking monies that they shouldn't have, trust companies mismanaging money. So at Rodel, for example, we make sure that all our financial statements are audited for transparency purposes. It's not a legal requirement that we do that, but some of the trust companies will make sure that that gets done. A curator bonus, for example, that would not be something that they would do. Costs, that is, I think, probably the biggest hindrance, though it shouldn't be, for courts and attorneys sometimes wanting a trust to be appointed because they believe that the trust's fees are exorbitant. And although they are usually higher, we should remember that often the court order should make provision for the defendant to pay for the trust fees. And if it's a road accident fund matter, the trust can actually claim, the trust company can claim for those fees to come back to them. So it shouldn't affect the capital amount that goes to the claimant. So that's something to remember. And also, because we have a team of experts at the trust company, we often are able to get better financial results just because we're able to use more sophisticated financial tools. A curator bonus might say that's not necessarily true, but because usually a curator bonus has so many people that they're managing, it sometimes is difficult to get kind of the more sophisticated and better investment strategies. And obviously now, because you've got a very good financial strategy in place, you're getting better returns, which means that also then the injured person is able to keep that capital award, will last longer. The last thing about a curator bonus and disability trust that I'll chat to you about is the area appointments. So being a single practitioner, curator bonus might prefer just to operate in one area, whereas a lot of, well, not a lot of trust companies, but many do have a national footprint. Rodel has a national footprint, and so we are able to assist in whatever part of the country is needs be, and we then can get the right people on the ground to assist. Okay, please send any questions through. Please put them in the chat box, whatever you need to do. And yeah, remember them. We're going to come back and take some questions. Right now, I'm going to hand over to Greta, who's going to continue from where we left off, which is now the trust company has been appointed. The attorney's he's done a handover, for want of a better word, to the trust company. And we now have hopefully had the first meeting with the family, between the family and the trust company. So Greta's going to take it from there. Thank you.
Thanks, Nicola. Will you stop your share? Okay, I've already had one question there, and I will cover it. I'm not just going to tell you what happens when we meet the family, okay? Let's just share quickly. So the trust service is very unique in the sense that it doesn't take over the parental care of an individual or of a child, or of if it's an adult, of the spouse and or of the family. All it does in a disability trust is it manages the medical needs or needs related to the incident that caused the injury or the disability. And in South Africa, that's not always a concept we all understand or necessarily accept, making it quite a challenge to deal with a trust. So when we meet with the family members for the first time and we are introduced to them, we explain to them exactly what the award was about and what the intention of the court is. And if they claimed for transport, for instance, to take a child for treatments and therapies, it does not necessarily mean they're going to get a car. Or, you know, if it's a house that they need, they claimed for an existing house's adaptations and or additions to make provision for a cerebral palsy child or for a blind child, rails, you know, ramps and things like that. And that's all that was in the award. It wasn't a brand new house. So that is basically then what managing the expectations is all about. But in effect, what we do at the trust company is we collate all the information that was dealt with during the trial. We submit it to the master. We get the trust registered. Now it's registered, and now it functions as an entity, the same as a company would perform. It's got directors, it can own furniture, it can appoint employees. Trust can do exactly the same. It's a legal entity. Instead of directors, we call them trustees. It can own property. It can appoint people to do certain things. But in doing so, you are using money that was awarded. Now, remember, when there was a trial in a disability claim, you might have proven 80 million rands of needs. You only got 10 or 15 or 18 or whatever. And that must last the whole life of the individual. During the trial, they discounted the needs, meaning that they know you're going to invest, and therefore they know that should you need a wheelchair in year 1, year 8, year 16, and so on, you must invest the money today so that you have the money in year 8 and 16 and so on, whatever the value of that wheelchair will be then. It is therefore extremely important from day one, from the day that the trust has registered, the bank account for the trust is opened, the funds were received, that we have an investment plan. We must make sure that the returns are big enough to be more than inflation and still provide for the immediate and most important needs such an individual might have. Now, when I talk about an individual, I mean a disabled child, a disabled adult. It's anybody that cannot take care of his own affairs. All right. To do that, I mean, I'm not a medically trained person. I might have been exposed to 100,000 medical legal reports in my life. I still don't have a medical qualification. For me to act, I need a professional person's opinion that has the relevant qualification. Therefore, we will always appoint a medical case manager to make recommendations. Now, what does that person do? Let's say it's an occupational therapist who then goes to the family, visits the home, look at the needs, look at the living conditions of the child or the adult with a brain injury, for instance, and recommend what needs would that person have now and for the rest of the year, and then also for next year and the year thereafter and the year thereafter. Nobody will really know, but at least her guess is more accurate than mine. And then we put that into a budget. which is actuarially calculated, and we make sure that all the needs are provided for when they are needed. And obviously, we don't know when a person goes to hospital or ICU, and then the whole budget is, then we start at scratch again. But at least we are budgeting to make sure that we can provide for the needs of that individual. All right. Now we've done the budget. Now the implementation phase starts. How do we do this? Yet again, the medical case manager will tell us, this child needs a very specific wheelchair, not the one that you buy at Dis-Chem. This one must be made because the head needs, assistance, or there's splints needed, or whatever bespoke equipment is needed. Maybe it's care, maybe it's special education, and so on and so forth. And then she will start with the implementation thereof. She will make the appointments. She will ensure the child reaches that place. Is there transport for the child? Is it necessary to buy a car? Do they live out in a very rural area where there is no medical treatments or therapies close by? Okay, let's go with step 2, block therapy, where the person would get a whole week's worth of therapy, and then 3 months later come back again and get a lot of treatment again. So all these things we call the implementation stage, and this can go on, well, if it's a cerebral palsy child on a level 5, it's probably for another 15 years, but any other person, it might be up to the age of 76 or 73, depends on what the life expectancy is. We will then hold the hand of the family. We will never move without the family's input. The families are often very grateful for that, but sometimes there's a lot of resistance because there are other children as well. But in essence, I mean, I'm just sharing this with you. We do the trust administration with a master, we do the financial management, and then the professional care management. And all of that is the trust. Now, I've had a question there from a lady, was it Marika, who wanted to know, let me just stop sharing there, who wanted to know, let me just go back to where it was. You have 2 disabled children and you wanted to know how a trust would work for your children. Okay, 100%, you can do that. You can even be a trustee of that trust. There's just one big question behind all of this. Where's the money? It sounds very hard when I say that, but what I mean is, if somebody needs to take care of your child, it is a business, and that business needs money to implement it. Who will pay for your child's treatment and therapies? Are you going to provide an investment? Is there money that you receive from somewhere else, or is this going to come from you and your children's father? What if you are not there? What is your plan with consanguinity? Yes, you can get somebody else to do it for you, but it's not an NGO. You need to find somebody that you can pay to do this. So in Rodel, we do have that system where you can pay monthly on whatever it is that you want us to do. It's very similar to the fee of an occupational therapist, if that would answer your question. I'm not sure. Anything else? Let me just see if there are other questions. I've got one from Brian. You're father of Dylan, who attends Irene Homes. You're also a financial advisor and have been in the industry for 19 years. All are welcome to contact him, and that's his email address. Thank you for that. You would love to add value to all parents, and so on. So exactly, this is what we do. We also outsource our wealth management. And as with Dylan, wealth management is a specialist field. You need to be a registered wealth manager to be able to manage other people's assets. We make use of Investec Wealth and a company called Jorgensen Berman Lascaris, JBL. We also have investments with Glacier, that's Sanlam Glacier, and Stanlib, which offer very similar reinvestment returns to what Dylan is offering. But the nice thing about a person such as Dylan is that he actually understands the needs. And that has probably been the biggest problem with, if I may say, banks in the past. They love to read spreadsheets and not always understand the exact needs of the individual who is the beneficiary of such a trust. And that's extremely important. I know with our staff, we are trained regularly to understand cerebral palsy, spina bifida, even if it's a brachial plexus injury of the arm, the nerves, retinopathy of prematurity, the blindness, and so on and so forth, orthopedic injuries and so on. So we are all trained in specifically those areas to understand it better. Okay, let's see if we've got more questions.
We've got a follow-up question there from Marika, who says, let me just go down. So would it then be better to register a testamentary trust where life insurance money can go to the trust?
I'm not against that, but that's probably for when she expects to pass away. But she still doesn't know who's going to take care of her children, Marika. I would suggest you do register a disability trust rather than a testamentary trust. A testamentary trust is not what we call an inter vivos trust. An inter vivos trust is a trust for alive persons, okay? With the testamentary trust is not necessarily what you are suggesting. I've got my trust specialist here. Let me just see what she says. Okay, she says you need a will for a testamentary trust. So in essence, Marika, you need to speak to a specialist about your succession plan or what you're going to do should you pass away unexpectedly, and who should care for your children. You need to make a plan. Definitely. Okay. Brian said you use Capital Legacy, who do all your clients' wills and can also arrange trust accounts. 100%. You can do that. I'm not sure if they work with disability trusts and if they provide the care. What I do know is we've got something we called our Rodel Fiduciary digital app, which is an application that each and every client can log into, where you can look at everything that's happened in your trust. You can look for your bank statements, your contracts, your doctor's notes, your medical reports. If you've sent in an invoice for payment, the invoice will be saved there, as well as the proof of payment. We make notes there, which you will have access to. You can also ask your questions and something like that, which is a great thing for transparency, meaning that we don't have people phoning us all day asking, am I going to get that couch or not? How much money is in my trust? Have you paid this? Have you paid that? They can just log in and look for themselves. It's all there. But yeah, Capital Legacy is well known. There are a few other companies out there as well. You're welcome to try them out.
Greta, there's a question there that says, who appoints a trustee? So I don't know if you want to handle that.
I will do. Thank you. So trustees are appointed by the Master of the High Court. And the Master of the High Court will only appoint a trustee if they can complete and sign a document where they accept the appointment as a trustee. And that form, it's a form J417, will ask you various questions. In essence, you don't need any qualifications to be a trustee. However, that form will ask you, have you ever been sequestrated? Are you currently sequestrated? Are you of sound mind? Do you have a knowledge of trust administration? Do you know what your fiduciary duties entail? And so on and so forth. And for all trusts, they must have a trustee meeting every year. Well, we have them often because we have so many needs going on through the year and circumstances that change, that we have regular trustee meetings every year anyway, but never less than at least one meeting per year. And that form and that questions are asked every year. Trustee, have your circumstances changed? Yes or no? And that is part of the compliance of a trust. Parents can be trustees. They don't have to be. There must be at least one independent trustee. What is an independent trustee? That is a person who will not necessarily benefit from the awards or the benefits that the beneficiary would receive from the trust. In other words, a parent might be or might not be. So if parents are trustees, the master will in all likelihood ask for somebody independent to also be a trustee. In our case, we always have a company as the independent trustee, which helps with succession. Should one trustee fall away or decide to not be involved in the trust anymore, the trust will not stop functioning. There will always be a representative of that company to ensure continuity. Okay, other questions? I love these questions, by the way. Oh, I see Ari Sirs is here as well. Hello, Ari.
Yes, hi, Ari. Greta, maybe something that I said I would touch on that I didn't touch on, and you've just touched on it briefly now, is the different kinds of trusts. Because I know going out there, you know, you meet with attorneys or whoever it is, and they say, oh, there's lots of trust companies, but there are trust companies and there are trust companies, and there are different kinds of trusts. And I think we need to emphasize, maybe you could, Greta, is that a disability trust is a very, very different, it's a very different vehicle. It operates very differently, and the requirements and needs of a person that benefit from a disability trust are very different. So perhaps you could just chat about that a little bit.
Thanks, Nicola. I can only speak of what a disability trust is. I can't really speak about family trusts, except from what I've heard. My daughter worked at a fiduciary, well, a bank at a family fiduciary department. And she would tell me that they've got family trusts and that it's family wealth and they've got lots of money and all the family members have a credit card and they spend it on the boats and on a whatever. And then they just top it up according to what they decide what the trust, that the credit card's details are. Or the purpose of that trust is to manage the family's wealth. In other words, where the money is allocated to and how much money does who get, and then invest it to make it grow and have great returns. Whereas with a disability trust, the purpose of a disability trust is to provide for all the needs, which was the purpose of the award in the first instance. And right at the end of the beneficiary's life, there's zero money left, which is a little bit utopian. Nobody knows when that person's going to die. But the purpose is 100% opposite of a family trust, meaning that the disabled person is the person who needs the money, who needs the care. And we've allocated our care needs in different categories, whether it's caregiving, treatments and therapies, pharmaceutical items, equipment, schooling, things like that. And we cover each and every coded item in each and every meeting to make sure that all the needs are covered. This is not done in a family trust. For them, it's about how much money is here now, how much is going up. There can't be this, let's invest here, let's invest there. It's a financial attitude. It's not necessarily a care attitude. And by saying that, I don't mean financial is not important. It is just as important. But this disability trust, heavy on care, the care aspect, the purpose of the disability award. Okay, anything else that you would like to know?
I see Ari's hand is raised.
Ari. I can't hear you muted, Ari. Okay, I can't hear anything.
Well, give Ari a chance to unmute.
Good morning. Can you hear me?
Now I can. Thank you.
Okay, thank you very much. I recognize a lot of you here, so greetings and thank you for your time this morning. I think it would be more appropriate for me to have typed my question, but my question combined with the comment is quite difficult to articulate in the chat box. And so indulge me in this conversation. And I know I can see that Andrew from Rodel is here, so he might want to participate. It's not a secret that NPOs, especially NPOs in the disability sector, that understand their disability constituency very well, are battling financially and are looking for alternative income streams besides the generic CSI call-outs to corporates, etc. And I've always thought that there would be a business opportunity or a relationship opportunity for, and I'll use physical disability as an example. So let's say the Quad Para Association of South Africa have an intricate understanding of the daily, the monthly, the yearly, the quarterly needs of someone, let's say with a spinal cord injury or somebody who has a severe physical mobility. And we have knocked on the door of Rodel and had this conversation before, but maybe this is a chance to see the response from other disability sectors that are here on behalf of the Alliance. Surely we could establish relationships with the various trust managers to say, look, we understand what the needs would be, the short term, the medium term, the long term. We understand what the infrastructural requirements would be in someone's home, and what they would be if they recovered a little bit or if they got worse. Isn't there an opportunity for a relationship in a financially beneficial relationship for organizations, let's say like Kwaza, through Rodel or whoever, to be involved in the trusts, so that you might have to reduce the number of occupational therapists you might have to have on your staff. If there are any OTs here, apologies. But use the resources and the expertise of an organization like Kwaza in terms of us having the expertise and knowing what the requirements would be. I mean, you've got your investment experts and you know how to work with the money, and we know how to work with the person's disability requirements. And so I'm pushing this agenda again and asking, people, asking the likes of Andre, Carlitz, and his similar firms, as well as Rodel and similar firms, to think about striking those sort of relationships with us, because we do have people that can give a lot of expertise, but there needs to be some sort of financial arrangement that I think we could be very useful partners. So that's my comment, and the question in it is, is this possible, or is this opportunity available? Yes or no? Thank you.
Ari, thank you so much. I think we did briefly chat about this when we met a while back, and so lovely to hear your voice again. Ari, so what if I'm understanding you correctly, so what you're saying is that there's expertise. Many of the members here have expertise that they could use. So for example, instead of us paying an OT to go out and do a visit or to go and see the injured person, that we would perhaps use someone with your expertise to go and do that. Is that what you're suggesting? You're still muted, Ari.
Yes, was just finding my unmute button. Yes, that's very
it's
much
along those lines.
Yeah, okay. Very much that we could do an access audit. We understand the equipment required. We even publish publications about that. Yes, absolutely. And also offering a resource in terms of where the parents and where that individual can get a lot of advice along the way. So we could maybe have an MOU with them. And in fact, most of that advice to the individual, if the individual is cognizant, has got cognizant to engage, would be just part of their privilege of being a member without there being any charges.
Greta, your thoughts on that? Because Greta is the one, Greta and her ladies are they're the ones kind of hands-on. I mean, it sounds fantastic because there's a wealth of knowledge.
100%. I agree. I think it's brilliant. Of course we will consider it, Ari. definitely. I think it's a great suggestion.
Any other hands? Any other questions, please?
We've got one other question there from Lamet Stavast. Do you manage a trust that was created through a will for disabled persons? Yeah, we can, but that's a little bit tricky. As you know, if the will says a trust must be registered, yeah, fine. But when was the will drafted? Was it before the disability or after the disability? And again, where is the funding for the management of a trust? So in essence, yes, but don't know if it answers your question fully, but you are welcome to connect with us directly. I'll ask my trust experts to come and talk to you and help you.
All right, we've got another question. How can people with disabilities themselves be involved in planning or the oversight of the trust set up for their benefits?
Okay, take me to that question. Whereabouts is it? At what time?
No, it's not. That's something I received by email.
By email. Okay, just read it, please. Just say again.
It says, how can people with disabilities themselves be involved in the planning or oversight of a trust set up for their benefit?
Okay, so it's a trust for self. Is that the way I understand it?
I think what they mean is, if the trust is set up, it's fair, all good and fair, but are they then allowed to also sit at the table and say, this and this is what I need, or have any input, any say in how it's managed?
Of course, yes. The key to any trust is what is written in the trust deed, because the trust deed will say what the powers of the trustees are and what is the purpose of this trust. And if the beneficiary of the trust is then the one that's also the founder, I mean, okay, it's not uncomplicated, but yes, definitely, of course, you should have a say.
Right. Thank you. I've received a couple of questions by email. Can I go ahead and ask them?
Yeah, sure.
Thank you.
Sure.
All right. It says, what are the most common mistakes families make when setting up disability trusts, and how can they be avoided?
When families set up a disability trust, with that, I accept it didn't come from court, and this is now let's say, a settlement. They received an award on behalf of their child, for instance, a Down syndrome child. Now they've got this trust. What is the most common mistake? The most common mistake, and believe it or not, is spending the money all at once early in the trust. And by that, I don't mean that you shouldn't be spending money. You should be spending money, but if it is a child that's going to live longer than you are, or as the family would, the most important years of that child is at the end of their life. The last 2 to 5 years are the most expensive years of a person's life. So if you buy a house and a car now, that money is gone. You might be buying an asset, but no car and no bricks and mortar grows as quickly as it would on an investment. So when you decide to spend money early on, just consider all the aspects around that, why you want it and why it is needed now, as opposed to perhaps later, maybe when the child is 18 or an adult and needs a companion, for instance, to help take care of that person. So that's the common mistake. First most common mistake is spending the money too early. The other most common aspect of a disability trust is not ring fencing expenses. If a disability trust was erected for one specific child, but there are 4 children in the household, that one child is not, it's not always well regarded by other children. Why is that child so special? Why has he got his own money? Why is he eating special foods and things like that? So they want to spend all the money of the trust on the whole family. That's also a common problem. You also get, you know, if you put money in a trust, it is protected against debtors or people wanting to attach furniture or assets, then they can't touch the money. So a common mistake, I would say, is not putting things of value in that trust to be protected for the disabled person. Those are the basic ones I can guess at.
Okay, then another question received was, are there any pending changes in South African law that may affect how disability trusts are taxed or managed?
Yes, there's currently a very interesting and lovely court case matter called the Keatley matter that was given by a full bench in the court in Johannesburg, the High Court. It was Judges Velaro, Keatley, and Anthony Miller. And they discussed what the powers of the Master of the High Court actually is and should be, what a trust should be doing and not doing, and the powers of a curator bonus and how it should be extended. We endorse that statement or that court case. We love it. We think it is fantastic. And then Judge Mlamba, who's the Judge President of the Gauteng Division, well, he was supposed to write a practice manual based on the Keatley judgment on what exact and how the common law should be extended, or the common law being case law and the Trust Property Control Act and so on, how it should be developed to make provision for actual or an indication of how it should be developed into. Because there's not much going on in the Trust Property Control Act. It's a very small act. And trusts are managed by way of either case law, which is common law, or directives from the master. And yeah, we definitely need something like that practice manual from Judge Mlambo.
Thank you so much for that. Further to that, I would then ask, are there any recourse mechanisms if someone suspects that the trust is being mismanaged? What can the family do?
Well, the first and foremost, they must be 100% convinced that they can prove it.
Yeah, of course.
A suspicion is not good enough. You need to be able to prove it, and then you need to go to the master and lay a complaint and then prove it to them. They will then present that complaint to the trust management company and ask them to reply or explain, and then they'll make a decision on that.
If I can also add in there, I stand to be corrected on this, Melanie, but I think there was also a case, and I can find it, where a beneficiary did suspect that the trust was using her funds incorrectly. And in fact, they were using her funds incorrectly. The trust deed made provision for the trustees to borrow money out of the trust. And she actually got another attorney, not her original attorney, she got another attorney to represent her and to investigate. So that is also an option. And they then actually sued those attorneys, and the matter went to the High Court. And those, there were very serious consequences, because obviously those attorneys were acting in completely the opposite way, or the trustees, excuse me. Yeah, the purpose. They had a fiduciary duty to protect the money, but were actually using it incorrectly. So I would say there is also perhaps an opportunity to find, and we can help if you want us to find an attorney that's well regarded to perhaps send a letter or investigate and find out what's going on. It definitely is worthwhile asking the questions.
Okay.
Yeah, we've seen so many in the media that are bad, eh?
Yeah.
Thank you so much. Then another question in the chat from Lily. She asked, does it mean then one needs to have a certain amount of money to register a trust?
Well, the purpose of the trust is to manage the money. So you do need money, yes, as such. But it doesn't say how much money. It depends on what the purpose of the trust is. If it is to maintain the needs, the disability needs of an individual, then it's a substantial amount. But I don't know what the purpose would be otherwise.
Yeah. All right. And then a question from Miranda. She said, is it better to create a trust for a disabled child sooner than later or after the death of the last parent?
No, as soon as possible. Even if it's not functional, it doesn't have it can be latent. But yeah, as soon as possible, definitely. I mean, if you're passed away, you can't do anything about it. You know?
Yes,
No,
of course.
definitely. I mean, if she means that if she puts it in her will that a trust should be erected and that her assets should be placed in a trust for her children, I think that's where she's going with this question. Yeah, she can do that.
And then a question from Jessica. What is the tax complication with trust monies? Are there any complications with trust money?
Yes, there are. A trust pays big time taxes. They are at the top end of the range. But if a person is permanently disabled, take care of their own affairs, they can apply for exemption. So with all our trusts, we apply for exemption. Then it's called a special A trust. And then they don't pay the 20% donations tax. They only pay on the level of a natural person. And then they only look at what did this person earn? And they didn't earn much. If you pay people directly, service providers, you pay the wheelchair guy directly, it's not an earning to the beneficiary. So then the taxes are very, very low. But yes, special aid trusts, 100%. It's a form called ITRDD form, signed by a medical practitioner and by the parent. And then, it needs to be submitted to SARS as soon as possible to get that exemption. Yeah.
The last question I received by email was someone that asked if a person is a beneficiary of a trust, if he or she will still be eligible for SASSA grant.
They've got nothing to do with each other.
Okay. Thank you. Are there any other questions, please? We've still got time.
Also, remember, a SASSA grant is based on different criteria as to the negligence or negligently caused disability of a person. That award was based quite on different criteria to the SASSA grant.
So just to clarify, Greta, you're saying they can apply for a grant.
Yeah.
Yes. It doesn't exclude them because there's a trust set up in their name. It doesn't exclude them from, they of course can still apply for their grant as they would normally.
100%. Some people are disabled because of the negligent actions of other people and sometimes not. Other people's actions are not even involved in their disability. They qualify for a SASSA grant. End of story. They are disabled.
All right. Another question. Can parents legally transfer or register property in the name of their child with an intellectual disability?
That's a legal question. A child under the age of 18 cannot act in her own capacity. Then she needs to be represented by a guardian or a curator or a parent and so on. So no, property cannot be registered in a minor's name. But if they have a trust, then it can go into trust where that child is a beneficiary. Yeah. And by the way, immovable property, such as a house or an empty stand, must always be dealt with by a conveyancer. That's an attorney with a conveyancing qualification, and it must be in writing. It can't be a verbal contract. It must be in writing.
Okay. Thank you so much. Let's hear if there's any other questions. This is a lovely conversation. I'm really enjoying this.
Yeah, well, Felicia, how can one check if a claim was